Honourable Senators, I rise today to speak to the 23rd report of the Senate Legal and Constitutional Affairs Committee on Bill C-46, the Trudeau government's impaired driving legislation. I am a member of the Senate Legal Committee and have been for the past 5 years. In that time, the Legal Committee has devoted significant time to studying the problem of impaired driving, particularly as it relates to the critical problem of significant court delays. We also studied various legislative initiatives seeking to reduce the frequency of impaired driving, both for drug and alcohol impaired driving. The impaired driving legislation currently before this chamber, Bill C-46, addresses both drug impaired and alcohol impaired driving. It was introduced in the House of Commons as a piece of companion legislation to the marijuana legalization legislation, Bill C-45. Perhaps a more cynical person might even suggest that Bill C-46 was created to provide some political cover for the government's untested drug legalization measures in Bill C-45. The first part of Bill C-46 creates drug-impaired driving offences and a regime for roadside testing of drivers based on a reasonable suspicion of impairment, much as alcohol impairment measures in place currently. The second part of the bill addresses measures concerning alcohol-impaired driving. Most notably, Bill C-46 proposes mandatory or random alcohol testing, which would mean that police would no longer have to have a reasonable suspicion of alcohol impairment in order to ask a driver for a breath sample. As many of you will know, I proposed an amendment at our legal committee to delete the random alcohol testing provisions of this bill, and that amendment, passed by a majority of committee members, is contained in this report, as our chair just told you. We heard a mountain of evidence from legal experts at committee that this random alcohol testing regime is unconstitutional. In fact, in my 5 years on the committee, I've never before heard legislation so roundly denounced as unconstitutional. The vast majority of experienced criminal lawyers who appeared before our committee expressed grave concerns about the charter implications of this provision. Witnesses told us that Bill C-46, and in particular the random alcohol testing measures, could be found to violate the Charter of Rights, Section 8, unreasonable search and seizure, Section 9, arbitrary detention, and Section 10b, the right to counsel. Adam Stephen Boney of the Canadian Council of Criminal Defence Lawyers told us that, quote, all of the charter nerves have been set tingling by this proposed legislation, quote. One very experienced criminal defense lawyer testified that random alcohol testing would lead to a decade of charter litigation. Another said that if these random alcohol testing measures passed, it would be Christmas for defense lawyers. Virtually every lawyer and legal expert who came before our committee found random alcohol testing to be unconstitutional. One exception was law professor Peter Hogg, who argued that Section 8 challenges of random alcohol testing would be saved by Section 1. Unfortunately, Mr. Hogg didn't appear before the Legal Affairs Committee, but instead submitted a copy of the written brief he had prepared for the House of Commons on the topic last year, meaning senators did not have a chance to question and challenge his assertions. Professor Hogg drew from Robert Solomon's evaluation of random alcohol testing in countries like Australia and New Zealand, countries that don't have a Charter of Rights and Freedoms. But renowned legal professor Don Stewart, the person who literally wrote the textbook on charter rights and criminal law, effectively refuted Hogg's claim. He said that in 35 years of charter challenges under Section 8, the Supreme Court has never justified a Section 8 charter challenge under Section 1. Lawyer Kyla Lee, herself an expert in impaired driving cases, delivered a compelling argument to us that Canadian cases about roadside testing and approved screening device testing that had been saved under Section 1 were successful because of 3 components: the reasonable suspicion requirement, the forthwith requirement, and use immunity. She went on to say, quote, in British Columbia in particular, we've eliminated use immunity because we have the immediate roadside prohibition scheme. That's out the window already. Now we're taking away the reasonable suspicion and forthwith requirements and making it simply make people blow or make people participate in these invasive testing procedures, quote. Ms. Lee also advised us in her brief, quote, there is no other instance in the criminal code that authorizes a search based on no articulable or legal standard. There is no other instance in Canadian law in which such a search has been held to be reasonable, quote. In the landmark case of R versus Oakes from 1986, the Supreme Court of Canada established criteria for determining whether a law that infringes on the Charter should be upheld as a reasonable limit under Section 1. That test, of course known as the Oakes test, requires the law to have a sufficiently important objective, a rational connection to that objective, be minimally impairing, or extend no further than is necessary to achieve that objective, and for there to be proportion between the infringement and the benefit of the law. Legal witnesses testified that the random alcohol testing provisions of Bill C-46 would neither be minimally impairing nor proportional under that evaluation. A number of witnesses alerted us to an increased risk of racial profiling under a random alcohol testing regime. Professor Stewart said, quote, "So what's the worry about taking out reasonable suspicion? The worry is undoubtedly racial profiling and the police force against racialized groups, Indigenous people, and vulnerable groups. I'm always a bit reluctant to state that. I was a prosecutor. I've worked with police officers. Are all police officers racist? Of course not. And many times when you assert that, they're very upset. But there's no doubt at all with the empirical data we've had in Toronto, Vancouver, Saskatchewan, and elsewhere that investigative detention under the practice of carding has resulted in huge racial discrimination against vulnerable groups." Professor Stewart then went on to say that the potential for abuse of mandatory checks is, quote, "exactly why the Supreme Court of Canada has put in place a standard of reasonable suspicion," quote. Another major concern is the impact that an avalanche of charter challenges will have on an already burdened court system in this country. Cases of impaired driving comprise one of the biggest gluts on our criminal court system, and that system is already overstretched to the point where it is breaking. For me, the Supreme Court of Canada's Jordan decision was a game changer. The decision, which established strict timelines by which court cases must be resolved or thrown out, has created a stark new reality where serious criminal charges, including charges of murder, sexual assault, and child assault, are being stayed because of extreme court delays. The charter rights infringement of random alcohol testing will only exacerbate this crisis. Most senators who have been members of the legal committee could tell you that I'm generally pretty tough on crime. That's why I don't want to see murderers and rapists go free because of court delays based on unconstitutional legislation, while law-abiding Canadians are potentially treated like criminals by the state. I thought it was interesting to hear the Justice Minister call our committee amendment to delete the random alcohol testing provisions irresponsible. I submit instead that it is irresponsible for this Justice Minister to be acutely aware of the court delay crisis in this country and to fail to take even the most basic actions like appointing more judges in order to address it. The Justice Minister's lack of action on court delays has been abysmal. Our legal committee put out an extensive report on court delays a year ago, the culmination of an intensive 18-month study, and the Justice Minister has largely ignored our recommendations. We recently heard from one of her officials that the minister still has 59 judicial vacancies to fill. This Trudeau government's priorities are all about politics, not about policy. A number of the measures in Bill C-46, which will actually prove effective for fighting impaired driving, were introduced in Conservative government legislation in 2015. The Liberals could have implemented those changes 2.5 years ago. Think about how many lives could have been saved by that. Instead, the Liberals introduced Bill C-46 in order to provide themselves cover for legalizing marijuana because they know that we will see an increase in impaired cases after legalization is passed. We have seen similar results in jurisdictions where marijuana has already been legalized. I had asked the Justice Minister to explain why it is that drugs and alcohol are treated differently under Bill C-46. Police need a reasonable suspicion to pull over a driver and administer a drug screening test, but not for a breathalyzer for alcohol. When I asked the minister to explain the discrepancy, she responded that the science for testing drug impairment was still evolving. Minister speak for just not ready. This begs the question, if that's the case, then why legalize marijuana now? As senators, our role is always to provide sober second thought on legislation. That is what we have done in our legal committee by voting to remove this unconstitutional measure from Bill C-46. Make no mistake, random alcohol testing would lead to charter rights violations, endless legal wrangling, and significant court delays. Our courts are in crisis, honourable senators. We cannot burden them further with clearly unconstitutional legislation. The consequences are simply too dire. Thank you.